Leeson Avenue to where the stop had occurred. Then we have the stop. And while there is case law that says that conflicting stories might rise some suspicion that crime is afoot, that's not the only thing that the court would need to consider. And it has to be a substantive issue to rise to that level. And the officer has to be able to articulate an articulable suspicion, reasonable articulable suspicion that crime is afoot. Now, Ms. Carey cites People versus Williams in her response to at least one of the motions, and I think it was in both, which is cited at 472 MISH 308. The court finds that that case is distinguishable from this one because the inconsistent statement, or the statement in that one case that doesn't make sense, is because that statement made law enforcement was factually just completely inaccurate and couldn't have happened. In that case, the occupants of the vehicle had indicated they were going to, I believe it was Sheboygan, they were going to stay at the Holiday Inn. There was no Holiday Inn in that town. They were going to be there for 3 days, but yet there was no luggage in the car. That rose to that level. While it might raise a suspicion, I don't think it's to a suspicion that crime is afoot, is that they disagree on how long they've known each other or where they might be going or are going to. But when I take where eventually they land on, they're going to Traverse City to drop Mr. Couples off, and they're on a path that could take them to Traverse City, I don't think gets us there. And then when we have the officer testifying that Mr. Couples was argumentative, I asked whether or not that's necessarily uncommon. He agreed that that was not necessarily an uncommon thing that happens. Then we get to the calling of the drug dog. We know the drug dog is called in at 12:18. Based on the testimony today, it takes approximately 10 minutes from Sergeant Hicks' testimony to get to where the stop had occurred. But before that, and telling to the court, is Deputy Ramirez began writing the citation at the time that he called the drug dog. That's the indication to the court that he determined at that time he only had sufficient evidence to write a no proof of it or no insurance ticket. And from that point forward, any amount of time it took to prolong the stop outside of the time necessary to allow the ticket to be written. As such, I find that the waiting for the drug dog to be called to the scene unlawfully prolonged the stop, and therefore any hit that drug dog made and any evidence as a result of that is suppressed. The search of the vehicle is hereby suppressed, and any evidence coming out of that. Sometimes there just isn't probable cause. Had the drug dog been called at the time that the stop had actually been made,